Hi, I'm Peter McDonald, the Communications Manager here at Aluvion. Recently, I've been reading a lot of confusing information about CASL and social media. So I've asked one of the lawyers here at Aluvion, John McKenzie, to explain how the new law will affect social media campaigns. Hi, John.
Hey, Peter.
I was watching the presentation you gave on CASL compliance yesterday, and you mentioned that CASL applies to all commercial electronic messages, not just email. How does that work with social media?
Well, it's a little bit complicated because the way CASL works will affect every social media platform differently.
Then let's start with the elephant in the room, Facebook. If I run a business, can I keep posting pictures of my new products or announcing new work-related events?
You can. This touches on one of the biggest exceptions of CASL when it comes to social media. CASL regulates commercial electronic messages that are sent to an electronic address. So as most people who use Facebook for marketing know, just because you post something on your company's Facebook page doesn't mean that all of your followers are going to see it. Content that's posted as a broadcast message, or one that only shows up on a follower's feed if they check in at the right time, won't meet the definition of a commercial electronic message because it's not sent directly to someone's electronic address.
If posting on your Facebook page isn't regulated by CASL, what is?
Any message on Facebook that's directed to a person, that would be caught by the CASL regulations. If you used a script on your Facebook that sent direct messages to each one of your followers or that posted on everybody's wall, this would be something that would be caught by the CASL regulations.
Yeah, that sounds like spam to me.
Well, that's the point of CASL. It's not designed to prevent businesses from promoting themselves or for making connections. What it is designed to do is limit the amount of spam that the general Canadian population is receiving.
What about Twitter? Are activities like mass following or automated favoriting covered by CASL?
The CASL law doesn't go into specific details when it comes to specific platforms, such as Twitter or Facebook, but it's likely that these types of cases wouldn't be caught by CASL. We're talking about direct messages here, so things like mass following and automated favoriting, while they may be annoying and somewhat spammy, they don't qualify as an electronic message sent directly to someone's electronic address. Now, that being said, although CASL might not cover these types of activities, Twitter has a very robust terms of service that deals very strongly with spam, so these kinds of activities may be caught by their terms of service.
What about direct messages on Twitter? They're sent to an electronic address, but only if you're following me. So if you're following me, does that mean I have explicit consent to send the message?
It doesn't. No. Explicit consent has to be directly linked to the type of message that the user is going to be receiving. So they have to actually know what they're going to be receiving prior to consenting to receiving it. However, there are some circumstances where you would be able to rely on what we call implied consent. One circumstance in which you might be able to do that is when you're running a contest using a unique hashtag, whereby people who want to enter the contest make a tweet and use that hashtag. In that case, there's an argument to be made that these people have accepted a gaming opportunity, which under CASL means that you have an existing business relationship. This means that you have implied consent.
Would a message that I have consent for still need to have the content requirements that are posted in CASL?
Absolutely, it would. All electronic messages under CASL need to comply with the content requirements, and there's two parts to that. The first is identification, so every electronic message must clearly identify the person who's sending it. You also need to have an unsubscribe mechanism. The best practice in this scenario would be to put a link to an external website with an actual formal unsubscribe mechanism that would allow people to indicate that they no longer want to receive direct messages from you.
What about Instagram or Pinterest or LinkedIn or Tumblr or Reddit?
Each of these social media platforms has its own intricacy, and how they work changes all the time. CASL doesn't specifically deal with each social media platform in and of itself. So it's important to remember that really, again, what we're dealing with here is sending electronic messages to a user directly. So something that would sit in their inbox or would bring a notification up in their profile. If you're going to do something like that, you need to have their consent. If you're doing something more like a broadcast, which isn't being sent directly to users, then you're going to be okay under CASL.
Thanks for sharing with us. Do you have any final thoughts?
Just like in any regulatory situation, if you're going to do something that's new or innovative and you're not quite sure if it's going to comply with the regulations you're subject to, it's always a good idea to talk to a lawyer first. In the case of CASL, a couple $100 of legal fees is really nothing compared to the potential $10 million fine the CRTC is authorized to levy against businesses who violate CASL. For me, I think it's a worthwhile investment for businesses who are doing something that they may not be too sure about.
Thank you very much for taking some time to talk with us today.
Thank you, Peter. Thanks for having me.